I'm Alan Mendenhall. I'm president of the Montgomery chapter of the Federalist Society. The way these things work is down the chain of importance, there's always somebody whose role is to introduce the important people, but who himself does not get an introduction. That is my function here today. So I'm going to introduce our panel, but I'll introduce actually just our moderator and then the panel. In a moment, I'll ask them to come take their seats. But I do want to say something because of Justice Mitchell's remarks. Sort of inspired me. But I was thinking about Edmund Burke, the 18th century Anglo-Irish statesman, a supporter of the American Revolution, and really the founder of modern political conservative thought. And he referred to little platoons. And what we have here in this room is a little platoon. And it's easy to underestimate the force that a little platoon can have. I think also of 19th century French thinker Alexis de Tocqueville, who came to America and observed that the United States of America thrived on these associations, these civic associations, and these communities, and that's what really distinguished America from the Europeans. And we still have a residual form of that spirit right here in this room. And that power, what each of us can do as we leave here today, can have effects beyond our imagination. So I hope everybody is inspired by the events today. Thanks to everybody for coming. I want to thank all of our sponsors for supporting us. It's Maynard, Balch, and Bradley, of course. Maynard, Balch, and Bradley. So just go look at the tops of the buildings out here and the signs, and you'll see all of our sponsors. At this point, I will ask our first panel and moderator to approach as I'll introduce as we're going to multitask here. I'm going to introduce the moderator, Annie Donaldson Talley, one of the greatest human beings I know. I'm very honored to call her a friend. Annie is a partner at Luther Strange and Associates. She recently worked in the White House after serving as deputy assistant to the president and deputy counsel to the president. Over the past 4 years, she provided outside counsel to the Donald J. Trump for President campaign, helped stand up and manage the White House counsel's office, interfaced with agencies across the federal government, and advised the President of the United States, White House counsel, chief of staff, and other senior staff across the executive office of the president on a broad range of issues from regulatory reform to executive nominations to the day-to-day issues facing the administration. Prior to her White House service, Annie Donaldson Talley counseled clients in the nonprofit, for-profit, political, and government sectors, as well as high-profile individuals in private practice at Jones Day and Patton Boggs. She provided strategic counseling to clients structuring their affairs to ensure compliance with the web of state and federal laws, and we know there are a lot of those, and represented clients in complex, multifaceted investigations, leading teams navigating issues of intense public scrutiny. Annie is also a veteran of 3 presidential campaigns and served in state government. She holds a bachelor's summa cum laude from the University of Alabama and her law degree from Harvard Law School, where she served on the Harvard Law Review. She lives in Montgomery, Alabama, with her very handsome husband, Brett, who's sitting over there. You want to wave, Brett? So thank you very much for coming, and thank you, Annie, for moderating this first panel.
And thank you, Alan, for that wonderful introduction of both myself and my handsome husband. Thank you all for joining us here this morning, and thank you for inviting us to be with you at this inaugural Alabama Federalist Society conference. We are with you this morning, I think you've already figured out, for a discussion about litigating with the states. And with us today, we have 3 distinguished panelists who have worked for and with states in various capacities. And gentlemen, I apologize because I don't have any remarks about how handsome you are or your families in my introductions. I'll start to my left. Ashley Keller is here with us today from Chicago. Ashley is the founding partner at Keller Postman, a boutique plaintiff-side law firm. Ashley brings experience as a trial and appellate lawyer, as the co-founder of a litigation finance shop, and earlier in his career at a hedge fund. Ashley is an alum of Harvard College and the University of Chicago, where he holds a JD and an MBA. And I'm sure your family is lovely and handsome. John
They're very good looking.
Okay, good. John Nyman is chair of the Appellate Practice Group at Maynard, Cooper, and Gale. He served for over 3 years as Alabama's Solicitor General, and there and elsewhere in his career, he's argued and briefed multiple Supreme Court cases on behalf of the state and coalitions of states. Nyman is an alum of UNC and Harvard Law School, and he continues to see issues related to federalism in his practice. I think both of you all were Kennedy clerks too, is that correct?
That's right.
Excellent. Last to my left, I've got Gibson Vance, who is principal at Beasley Allen, a fellow Montgomery resident. Vance was recently installed as the president of the Alabama Bar Association. Congratulations.
Thank you.
He's been representing clients in jury trials since his 3rd year of law school, and I have a couple of strict policies. 1, as a lawyer, never to do math on the fly, and 2, never to do math on how long that means you've been in practice. Vance is an alumni of Troy University and Faulkner University's Jones School of Law. Thank you all for being here today.
Thank you.
We've all heard the old saw about states being the laboratories of democracy, but over the past few decades, we've seen states really become powerhouses driving legal policy, especially in states' attorney general's offices, but also in governor's offices across the country. Those states had long been involved in driving their own policies, their own law enforcement, criminal law, and other policies. The states really flexed their muscles when they teamed up together in the massive tobacco litigation and settlement in the 1990s. In the decades that followed, states banded together to mount pushbacks to federal government overreach, a function that has continued to grow over the successive presidencies since. Now, if you think about it, whenever a president of either political party attempts to make a major policy, it's likely that policy will be litigated in the federal courts by the states. Some examples of this, in case you don't believe me. Under President Obama, some major policies that were litigated: the Clean Power Plan, the Endangered Species Act, Waters of the United States, this little thing called the Affordable Care Act, which was a little bit of a hullabaloo for a little while there in the courts, the contraceptive mandates in HHS, DACA, DAPA, and other immigration laws. This expanded under Trump, who by this time in Trump's presidency, about a year and a half in, had been sued 69 times by blue states at the time. Think about the travel ban, sanctuary cities, the repeal of DACA, the other side of the coin, and other immigration actions, religious liberty mandates, the repeal or rollback of various countless environmental regulations, or even the routine setting of emissions standards. Again, I mentioned by this time in his presidency, Trump had been sued 69 times by the states. Not to be outdone, the Republicans have now sued 79 times the Biden administration and had some significant wins along the way. Think about the immigration deportation moratorium, the Remain in Mexico policy, Title 42 immigration, oil and gas leasing moratorium and other environmental measures, vaccine mandates. There was this provision in ARPA, the pandemic relief funds, that prohibited states from using ARPA funds if they cut taxes, and a number of other things, not the least of which was the recent blockbuster case at the Supreme Court, West Virginia versus EPA, the Clean Power Plan, from which we now have the major questions doctrine. All the while, states are also driving policy at both the states and national levels on social issues, environmental regulation, and more, both by engaging in litigation with the federal government and increasingly, maybe most relevantly to some of the folks on stage with me today, with private corporations through consumer protection statutes or even maybe some more novel legal theories. Gentlemen, let me thank you all again for being with us today to talk about this issue. Each of you comes at this topic from very, very different perspectives, and I'd like to start by stepping back for a few minutes and turning the floor over to each of you for some brief introductory remarks and thoughts about your experiences working with the states. I'm happy to let you all fight over who goes first or call in some. Ashley, you want to start?
The perils of being immediately to her left. Thank you for that kind introduction. Let me quickly just tell you how I'm representing states and then maybe transition to some of the things that I hope my clients will be looking at and thinking through in the coming years. So I have the privilege of representing Texas, Indiana, the Dakotas, South Carolina, and Idaho in an antitrust action against Google for monopolizing the advertising technology space. I represent Texas in a biometric privacy case against Facebook, or Meta, as they now like to call themselves. And I represent Arizona in their action against Purdue and the Sackler family for the scourge that is the opioid epidemic. So a wide variety of different matters. But far more interesting to me is sort of the moment in history and time that I think we find ourselves in. And I'd like this room and the people who represent states as public servants to hopefully take away, or at least think about, two different points. The first point is corporations are behaving very, very badly today. And I think hearkening back to Justice Mitchell's 1982 and Reagan's America, we conservatives have a healthy and understandable instinct that we should allow the invisible hand to operate, and essentially anytime governments are interfering with corporate activity, that's a bad thing. It reduces social and consumer welfare, and it doesn't have salutary effects. And normally, if Milton Friedman were still in charge of the boardrooms of these large companies, I would agree with that sentiment. But you need to shake that instinct. This is not your grandfather's Chamber of Commerce. Corporations are engaged in flagrant lawlessness that is hiding in plain sight. We all see the headlines. Not a day can go by where we don't witness corporations undermining fundamental American values that the people in this room care a great deal about. Just yesterday, I saw that Pfizer announced a program, a scholars program, where whites need not apply because their diversity, equity, and inclusion policies, which are euphemisms for flagrant lawlessness, have spurred them to give lots and lots of money in a flagrantly racially discriminatory way. And everybody knows that there are 1,000 other examples that I could point to that would occupy all of the time of this panel where that's occurring. States absolutely have a role to play in prohibiting that sort of lawlessness, and hopefully getting corporations to go back to the Milton Friedman model where they want to maximize profits and shareholder value, and our 1982 instincts can come back into play and we can let them do that. But that's not the moment we're in right now, and we need people who have the official law enforcement capacity that you've been entrusted with to ensure that that misbehavior is policed. And the second takeaway, which is going to be a little bit shameless and self-promotional, is you don't have to work with outside counsel that's going to fund all of your political opponents, as most members of the plaintiff's bar will. Conservative plaintiff's lawyer is not an oxymoron. We're out there. We don't always advertise our politics, given the nature of that bar, but I don't care what people think about me, so I'm fine being outed as a conservatives plaintiff's lawyer, and proudly so. And so there are folks that you can work with when you need outside resources who see the world the way you do, and it would be a privilege to help you tackle these important societal battles.
So I'm next on the list, apparently. I'm John Nyman. Just thrilled to be here. What a room and what a crowd. Let me give you a little bit of my history so you have a sense of what my experience working with and for the state has been. I started out my legal career at the Bradley firm here in Birmingham, and working with Kevin Newsom and Matt Lemke and Andrew Brashard. Actually did quite a bit of work for the state, which, as many of the people in the room know, farms out a lot of its legal work to outside counsel, both plaintiff side and defense side. I got sufficiently interested in that line of work, working at Bradley, that when Luther Strange was elected AG in the fall of 2010, I followed him to Montgomery and was his Solicitor General for about 3 years. Was lucky enough to recruit Brasher to come be one of my deputies, which turned out to be great for the state, and I think great for the U.S. Court of Appeals for the 11th Circuit. We had a couple of fun cases at the Supreme Court, one or two that weren't so fun. When I left the SG's office, I joined Justice Mitchell, then we just called him Jay, convinced me to come to Maynard Cooper, and it's been a great move for me. I've gotten to continue to do quite a bit of work both for the state and with the state. So have represented the state both on the defense side and in at least one case on the plaintiff side in some litigation. I also have coordinated with the state in the sense that I've got clients who, for various reasons, want to seek the state's help in terms of getting an amicus filing or the like, or supporting the state's cause and when it's defending a particular piece of legislation that the client thinks needs to remain on the books. Given the fact that I'm still representing the state, I do have to say at the outset, I've got two goals here today. My first goal is, since Will Parker, General Counsel for the Governor, is in the room, and since Steve Marshall will soon be here, and I know many of his deputies are here, my first goal is I just don't want to say anything that really makes them mad at me. And given the nature of this topic, I think it's going to be impossible for me not to say something that might have it might not be entirely consistent with every single policy that those two offices are employing. So please forgive me in advance, guys. I love both the governor's office and the AG's office here. I'm not trying to criticize you. I'm actually trying to kiss up to you in every conceivable way. My second goal is, since I'm sort of like the defense guy on this this panel, I'm really trying to stir the pot a little bit with respect to my other panelists. I feel greatly honored to be on the panel with not only Annie as our moderator, but the other two folks who are going to be speaking today. If you didn't attend the FedSoc annual meeting last year and go to the Rosencrantz lecture and see Ashley's performance there, I'd highly recommend that you go to none other than Google.com and Google Ashley Keller FedSoc Rosencrantz lecture. He debated, John Allison, you debated, former BB&T CEO, about the relative dangers of the government and big corporations. It was fascinating. When Ashley gets going, it's like nothing else. And so I'm very much hoping to get him going as well. Same deal with Gibson. Gibson is one of the premier plaintiffs' attorneys in the state. My clients have been fortunate enough that I've never actually been on a case opposite Gibson, so I'm glad to get to know him today. But I also, I'm really interested actually in hearing from both of these guys about the following hypothesis, which I'll just sort of throw out there at the beginning of this talk. It's my sense that, let's say in the last 20 years or maybe 12, we are seeing conservative attorneys general, FedSoc-type attorneys general being much more comfortable playing plaintiff's lawyer and being on the left side of the V in civil cases. And the question I'd like to debate a little bit today is, first of all, am I right about that development? Is my anecdotal observation correct, or am I just sort of dreaming things up? If I'm right about that, query, is that development consistent with sort of FedSoc conservative principles relating to the separation of powers and otherwise? Is it a good thing? And the final question I have is, if we think it's not quite consistent with those sorts of principles, or is it too late to tap the brakes on that? Or should the brakes be tapped in a selective way, with the AGs continuing to push the envelope in certain directions, but withdrawing in other areas? So with the pot so stirred, I'll hand off the baton to Gibson.
Do we have a court reporter here? Because I don't think if we can just
we have a camera. It's such an honor to be here. It's such a privilege to see judicial icons, to serve on this panel. But this is the second time I've spoken to the Federalist Society. First time was about 11 years ago. I was president of the American Association for Justice, and they asked me to speak at your annual convention. And quite frankly, I was a little bit nervous. I had a high level of anxiety because I pictured this group as some of the smartest lawyers in the country, and I still do. So I was nervous, but then a day before my speech, someone told me that C-SPAN would be covering the whole convention live. So that anxiety went up a little bit higher. So I called my brother, my older brother, Alan. He's brilliant, perfect score on the SAT, full scholarship to Georgia Tech. I said, will you please watch the speech? And when I get through, I'll call you and you give me some honest, objective feedback. So the speech started, and I'll never forget, I'd practiced so many times. My opening line was, AAJ, the American Association for Justice, is a very unique organization. We have one goal and one goal only. So I gave my speech. I talked about the evils of arbitration, Iqbal, Twombly, preemption, and quite frankly, I was feeling pretty good about how I did. At the end of the meeting, several members of the Federalist Society came up to me and said, hey, we're members of AAJ too. We believe in the 7th Amendment. We're for you. So I walk out of the convention hall feeling pretty good about myself until I called my brother. I said, Alan, did you watch? He goes, yeah, I did watch, in fact. I said, do you have any comments? He goes, yeah, I wrote several pages of notes. I said, well, let's start at the top. He said, here's the deal. Gibson, never say the phrase, very unique. I said, what? He goes, unique doesn't need a qualifier. Doesn't need a modifier. I'm like, that's what you got from my speech? He said, but no, I have some good news. I said, I hope so. What's the good news? He says, the good news is your accent is so thick, no one understood a word you said. I'm coming from this panel from the perspective of a plaintiff's lawyer. I have one goal. We currently represent the state of Alabama in the opioid litigation. When I leave here, I still want to represent the state of Alabama in the opioid litigation. We also represent Georgia in the opioid litigation. We've represented Mississippi, South Carolina, Tennessee, Louisiana, Kansas, Utah, Alaska, Hawaii, and New Mexico. And it's been fun. We've learned a lot over the last 15 years of this representation. I want to talk today at some point about actually how we get these cases. It's very, very difficult to get these cases. I want to talk about assembling the right team to prosecute these cases. And really the main takeaway I've learned from representing so many attorney generals is the fact that they're unlike most of our clients. Most of our clients do what the lawyer thinks should be done. We keep them, we tell them what's going on, we communicate with them, but they let us make the decisions. Have you ever met Steve Marshall? He is not that kind of way. He has been the quarterback of our team, the coach, and the owner of our team. He's made every decision, and we've just been there to help him. And I think it's been a great relationship, and I think we brought a lot of money, needed money, from this opioid crisis into the state. Once again, Jay, thank you for inviting us, and I'm happy to be here.
Excellent. Well, maybe I'll follow up with your remarks real quickly. And states are, drivers of law and policy, and they're also a body of people and function under a constitution, not just parties to litigation as some of your private plaintiffs are. Maybe we can talk a little bit about some of the unique aspects, not very unique, but just unique aspects of working with states in your practice as opposed to those private parties, either in advising them, representing them, or advising clients when working with them. What are those challenges, and how are you involved in trying to solve them?
Well, the first challenge, once again, is getting hired. It's convincing an attorney general that they need to hire outside counsel. In preparing for this, I talked with Attorney General Marshall yesterday, and I got his thoughts. And his main thought was, you have to find a niche, a type of practice that the Attorney General's office probably could handle by themselves, but it's better to hire outside counsel. These cases are extremely, Ashley, as you know, expensive to litigate. But then the challenges, as I mentioned, communications with the Attorney General's office. You can't really make a move without their express permission in assembling the right team. And I think we would be doing a disservice if we didn't use the word politics at some point, because that's kind of an overarching theme. When we were hired by the newly elected Attorney General Chris Carr in Georgia, he put together a team that included Roy Barnes. Roy Barnes was the former governor, Democratic governor of Georgia. The same Roy Barnes that has spent a good bit of money this cycle supporting Chris Carr's opponent. Good lawyer, qualified, but it was a team that I think the Attorney General could be proud of and could show that no politics were involved. But politics are involved. We've represented all these states. We've only been fired one time, and that was by your business associate. Attorney General Strange had gotten elected. I don't know what he did the first day as Attorney General. I'm certain of what he did the second day. He called us into his office, me and my managing partner, and I think he had about a 30-minute speech prepared. He got about 5 minutes in, and I raised my hand. I said, "General, are we fired?" He goes, "Oh, yeah, you're fired." So politics does play a big part.
He didn't want to pay the bill for the rest of the hour.
That's it.
Ashley, you have a follow-up?
Sure, I'll be brief. The two downsides of working with states are they don't pay very well and they micromanage everything that you want to do. But there are real upsides. They don't have a profit motive. They're doing it for public interest-minded reasons, which if you care about the policies that you're pursuing is a dream come true. You don't have to take a settlement offer if it doesn't actually lead to structural relief or a change in the behavior that you're going after. And I love that aspect of working with the states. They care about their constituents. And the political aspect is fascinating to me, and I view it as a positive. Again, hearkening back, John, you know I'm going to take the bait, so you don't have to worry. You've stirred the pot adequately. Yeah. At this political moment in time, I think that the interests of red state politicians lines up really well with the sort of lawsuits that we're talking about. Our base of voters cares a lot about this stuff, and sort of, again, the libertarian pro-business instinct that I hope comes back into fashion when it's appropriate is not where our voters are right now. And so going after wokeness, racial discrimination, all of the things that we find detestable about corporate America today, I think is good politics in addition to good policy.
John, do you have anything?
So what question is on the table here?
Anyone you no.
What's the most unique aspect
Yeah.
of? Well,
working with or for states.
Ashley stole my line. Since Will Parker is here, and I never fail to take advantage of an opportunity to complain about this, the most unique aspect, very unique aspect of working for the state is the rock bottom level rate that they somehow force us to charge. I have other clients in the room, and I would implore you not to speak to Will Parker about how he's able to pull this off. Every couple of years or so, AL.com comes out with the scandalous article about how much the state is paying law firms for their services, and people always forward me the article if my name is mentioned, and I want to say to them, look, the bigger the number, the bigger the loss that I have taken here. In all seriousness, no, and this sort of relates, I think, to Ashley's take on things. For me, the most unique aspect of working with the state is, as opposed to private clients, is it's a little less clear kind of who the client is and what the client wants. It's more amorphous. When you have a private client, you're dealing generally with the general counsel or the CEO or the board, and you also have a pretty good sense of what's a good outcome. Usually the client is being sued for money damages, and the client has a pretty good idea of what would be an acceptable result, whether it's a goose egg or a settlement up to X amount. With the state, even if monetary damages are at issue in a case, it's not always clear what the right number is to serve the state's interest. But in the overwhelming majority of cases where you're working for the state, it's not really about money. It's about some other value and figuring out what is an acceptable result from the state's perspective, what's the right outcome of litigation, short of an outright win, is quite difficult. You've got in this state, we don't have a unitary executive, so often you're dealing with different statewide elected officials who have a stake in the matter. Sometimes the legislature is very much a stakeholder. You're defending the law that they passed, and if you're in a situation like we were a few years ago with respect to the immigration-related law that Alabama passed, we fought the fight in the district court, we fought the fight in the 11th Circuit, sought en banc, got denied, sought cert, got denied. The case was still, though, at an interlocutory stage, but it just sort of made sense to settle the case in particular ways and trying to figure out, what was acceptable in terms of which provisions the state would agree, the Attorney General would agree would not be enforced. was sort of a difficult proposition, speaking to all the relevant stakeholders and vetting with them. Ultimately, it's sort of up to the Attorney General to make his or her best decision about what's right from the state's perspective. But I just think that makes the process of litigating on behalf of the state a little more tricky than it can be in the private sector.
One quick follow-up for you, John, is you've been both a staffer inside the Attorney General's office and outside counsel to the same office. How has that changed? How does that change your role, if at all?
I really don't view it as changing the role in any significant way. I mean, when private sector attorneys are asked to represent the state, they are appointed as deputy attorneys general. So under the law of Alabama, they are serving at the pleasure of the Attorney General. They're operating at the direction of the Attorney General. It's your responsibility to check in with the Attorney General and make sure they're apprised of all developments in the case. I mean, I think the only real difference is that you're not working in the office on Washington Avenue in Montgomery. Instead, you're working out of your own law firm and with your own colleagues.
Let's change topics a little bit to follow up on something Ashley is very passionate about. I'm going to help John stir the pot a little bit here. Conservative states, and especially the AGs in conservative states, have long considered themselves the last line of defense of individual liberty. I'm not sure who came up with that line, but it was a good tagline. It seems now that we're in a time where corporate America often bends to the will of so-called environmental and social justice forces, even when it doesn't outright join them. And we've seen their trade associations and others associated with them staying out of fights that they would have led 5 or 6 years ago. Under the Obama administration, when you saw some of this pushback to federal government overreach, you often saw red states and private forces joining together in some of these lawsuits. You don't really see any of that, very, very rarely at least anymore. So I would suggest that in some cases, states are now the only line of defense against incursions to individual liberty. Is that, well, I'm not even going to ask the question this way of Ashley because I think I know the answer, but what are you seeing from your perspective? Are you seeing that that dynamic shift, and what do you think of that? How does that change the landscape? And I'll let you start.
Like any good lawyer, you asked a question that you already know the answer to. Yes, I'm definitely seeing that. And to harken back to Milton Friedman, my own hypothesis about what's happening right now is we're in this strange moment where Milton Friedman's model of the firm has broken down. So those of us who remember Milton Friedman with his cool patches on his suit and the weird speeches he gave, brilliant guy, and his model of the firm was essentially shareholder primacy. The objective of the firm is to make money, to maximize returns for the shareholders, and to stay out of everything else. And so you could usually count on corporations to essentially be Switzerland on lots of issues and try and maximize the return on invested capital or return on equity so that shareholders can get fat dividends and the stock price can go up and sort of normal capitalist instincts like that. ESG, wokeism, DEI, all of these sort of words and acronyms that we hear thrown around today, I think are something that Wachtell and Marty Lipton have sort of come up with, which is stakeholder primacy, which was sort of modeled to displace, and I think has successfully displaced Milton Friedman's view of the firm, where you have directors, officers, and other corporate agents who now say that their job is to take into account shareholders and think about profits, but it's a Justice O'Connor style multi-factor balancing test, and they're also allowed to take into account the environment and the needs of their employees and the community and past racial injustice. And so when you throw that all into the mix, they have these huge multi-billion-dollar treasuries that they can utilize not to maximize shareholder profits, but to promote causes that the directors and officers support. And lo and behold, today, the causes that they support are almost universally against the values that the people in this room cherish. And so, yes, I think that it is a huge problem today that corporations are not engaged in the profit maximizing litigation that you would have expected previously, challenging environmental regulations that don't have a basis in law or are arbitrary and capricious under administrative law principles, things like that. And so it's going to fall to the states, largely to take on those responsibilities to ensure that oftentimes federal regulations and statutes are compatible with broader principles and the Constitution. And similarly, it's going to be the responsibility of states, I think, to go after corporations when they're engaged in lawlessness and to sort of answer partially a question that John posed. Of course that's consistent with the values of the Federalist Society. It's emphatically the province and duty of the judiciary to say what the law is, and the law is what's written down in the statutes at large and the Constitution. And if corporations are violating the laws of the United States and the states, of course we should go after them for that. That's consistent with rule of law principles. So I think it would be very antithetical to conservative values to turn a blind eye to corporate lawlessness just because, we want the corporations to keep making widgets or putting up Instagram photos or whatever other valuable service they putatively provide to society.
Anyone else want to take a crack at that?
I won't say it as well as Ashley said it, but I look back at what our firm has handled in the state of Alabama. I don't see it as a red state or blue state issue. I don't see it as Republican or Democrat. We represented the state in the BP oil spill. We represented the state in average wholesale pricing. That is where all the pharmaceutical companies got together and overcharged state Medicaid departments millions and millions of dollars. And we're currently representing them in the opioid litigation. I really, as an attorney general, I think those are easy decisions.
Yeah, and unsurprisingly, I'll push back a little bit on the premise of the question about AGs long viewing themselves as the last line of defense for individual rights. I'm not sure that, I think that depends on the definition maybe of the word long. And again, this relates to my own sort of anecdotal observation, and I'd love pushback on the notion that maybe I'm just wrong. But I would say 20 years ago, the general view was that the AG's office sort of played defense. You obviously played offense on the criminal side. You prosecuted cases. You defended convictions that the state obtained against criminal defendants. But on the civil side, your job was generally to defend the state against lawsuits, whether it's prison litigation or attacks on states to the constitutionality of state statutes. So I question whether AGs have always viewed themselves as the defenders of, say, individual rights as opposed to the defenders of the state government itself and governmental prerogatives itself, which for obvious reasons are not always simpatico with robust understandings of individual rights, especially on the criminal side, but even on the civil side as well. So that just raises the question, I suppose, that Ashley has already answered to a certain extent. Does it make sense for the states to be pretty aggressive on the plaintiff's side and trying to vindicate individual rights, which I have no problem. Certainly when I'm not in the governmental role of vindicating individual rights, I like my own rights just fine. But it does raise a couple of sort of problems in the sense, to the extent we think about the AG as representing the state. Problem number one, and maybe I'm just a dinosaur, but I remember when I started as SG, there was a case out there called Massachusetts versus EPA. And we thought, even in the AG's office, that decision was nuts because it allowed Massachusetts to come in and sue the federal government and to compel certain governmental action. And from one perspective, from the state's perspective, it looked great. Like the state could come in and litigate and throw some elbows. From the other perspective, from as a matter of separation of powers and the like, it seemed to set a dangerous precedent that this was how law was going to be made. Since that time, that Massachusetts, obviously, that was a blue state at that point, and was pushing left of center type prerogatives. Since that time, the folks in the red states pushing right of center prerogatives have taken advantage of that ruling and greatly expanded the concepts, I would say, of state standing. But again, my question is that a good thing? Does it make sense to allow states to come in and vindicate the rights of individuals rather than leaving the vindication of individual rights to those individuals themselves? The second problem I think that can arise when states are pretty vigorous in coming in on the left side of the V in a civil case is that you may create law when you are the AG plaintiff that may be bad for the state, depending on what the nature of the claim is. Like for Ashley's book of business related to antitrust, I don't think that's a problem at all, right? I mean, the states may have different concepts of what is good antitrust policy, but it's hard to imagine one state pushing antitrust policy in one direction that comes back to actually bite the state in some case where the state gets sued. But the states are taking positions on all sorts of constitutional questions as plaintiffs, like dormant commerce clause cases where you have states going out and suing other states to preclude those states from regulating in certain ways that may lead to great results for the state in that particular case. But the problem is, in the next case, when Alabama sues California on some dormant commerce clause theory, what happens when Alabama creates like really expansive dormant commerce clause doctrine and then Alabama gets sued by California in the next case with respect to some regulation that the AG is required to defend as a matter of constitutional duty. But both of those concerns, I say, counsel a little bit of restraint.
Can I respond to that?
Of course.
I think that there's a false premise, respectfully, with what you're asking for. I think that states should be involved in righteous causes that support the actual reading of the Constitution and the statutes. So, of course, Massachusetts versus EPA is a terrible decision. Just because I'm advocating states acting as plaintiffs doesn't mean that I'm advocating that they pursue legal arguments that are erroneous and that the people in this room would disagree with. And that's a full answer to the Dormant Commerce Clause, too, because there is no Dormant Commerce Clause. So states shouldn't be supporting litigation that relies on those sorts of arguments. I also have to quibble with your nomenclature. When states bring cases, whether as plaintiffs or defendants, they don't create law, because judges don't create law. The laws are written by our politicians in legislatures. But it is true that you could get a bad legal opinion that through principles like vertical stare decisis could be binding in future cases, and that's the risk you take in any litigation. But what you should be doing is making the correct legal arguments to vindicate principles that you care about and that your constituents care about. And when corporations or the federal government are violating the laws of the United States or the laws of the Constitution or of state statutes and constitutional principles, then elected officials in the states should go after that. So you should do it through the lens of the principles that you espouse, which I think are broadly in keeping with the principles of the Federalist Society. But when those principles align with you being on the plaintiff side of the V, you should do it.
Let me ask just a quick follow-up question, because you mentioned that certain readings of the Constitution, the ones that most of the people in this room probably agree with, are correct to go after, and it's fine to go after on one side of the V. But what about novel legal theories, pushing the law to new places? And I know some of the lawsuits that are out there right now rely on these quote-unquote novel legal theories. I think some of the antitrust theories may not be the exact way that the antitrust has been applied in the past. Public nuisance is surely one of the most debated legal theories out there right now. What do you think about that? Where do you draw the line, especially when states are the litigant?
Yeah, so for private clients, I draw the line at, Rule 11 and zealous advocacy, because that's what I have to do. But, are we being recorded? I guess it doesn't matter. I'll say it anyway. I don't love novelty when it comes to the Constitution. We should be looking at history and tradition and the original public meaning of the document. And so novelty is antithetical to the way that we ought to be pursuing constitutional cases. And just because you don't like a policy outcome doesn't mean that you should make a constitutional argument. And so, again, if I had to make the argument on behalf of a client because zealous advocacy requires it, of course I would. We're attorneys. That's our job. But as elected officials in states, I'd encourage you to stick with your principles and not join a lawsuit just because you disagree with a policy. And you could make some novel constitutional argument, but you don't actually believe that it's correct. And public nuisance, antitrust. We don't need to get into a long discussion about whether the laws are brooding omnipresence in the sky and whether you believe in natural law principles, laws discovered versus made. I tend to not believe that judges are making law, even in common law areas like antitrust. I hope that they're using reason and intellect and sort of traditional principles to find objectively correct answers. But those are areas that are, of course, more susceptible to creativity because it's not pointing to a statute that has sort of 3 subsections where there's text and you can disambiguate that language using the traditional canons of construction. There is some element of loosey-goosiness associated with that, and we just tolerate that in certain areas of law like antitrust.
I see your pen going, Gibson.
Yeah, I was just going to say, from a practical standpoint, when you're representing conservative attorney generals, they're not going to let you push the envelope too much. Once again, they're the quarterback. They're the ones making the decisions. And public nuisance, obviously, we've used that in the opioid litigation quite successfully. But you know, it's back between the relationship between the plaintiff's lawyers and the lawyers representing the attorney general in the plaintiff's case. Back to the fee issue, I don't know that most people understand this. Probably 12 years ago, we negotiated a fee statute in Alabama. Attorney General Strange and I agreed on a pay structure. And I think the top pay is 8%, a fee of 8%. And that's limited to, I think, $50 million. And I think we're doing the Alabama litigation for less than that. So you put a lot of work in it. Sometimes it works out, sometimes it doesn't. But it's not a panacea.
John, going back to the last line of defense, do you think that when the states started getting used to defending on federalism grounds and then moved a little bit more into the individual rights grounds, I mean, is that a big change for you? Do you think that that is different in kind?
Well, again, I mean, this sort of goes back to the question of whether my anecdotal observation is, empirically correct. But I do think there is a difference in kind, perhaps, between the kinds of positions that the states are taking in current litigation. And I'm not really thinking so much about plaintiffs' litigation versus defense litigation. But if you look at amicus briefs filed at the U.S. Supreme Court, for example, these days, it at least I think was conceivable 15, 20 years ago that the states would generally align and come to some sort of consensus about which side of the case was the one that was pro-state. I mean, it was generally the side of the case that would allow states to take the most action they possibly could without any sort of interference from the courts, and that might not always be a pro-liberty perspective. I mean, if you look at amicus briefs that are filed at the U.S. Supreme Court these days, including in the redistricting case that Justice Mitchell mentioned at the outset, I mean, you have states coming in to the redistricting litigation where, in theory, the states either ought to support Alabama because they don't think that the Voting Rights Act should be employed in the way that the district court suggested there, or just have no dog in the fight, right? Like, they don't care one way or the other which way this case comes out. But you have several states coming in and saying to the Supreme Court, you should affirm the decision. You should find Alabama liable here. And the only real explanation, I think, for that is that attorneys general are concluding that for various reasons they think that this particular position on the Voting Rights Act or individual rights is the correct one. And it's not really clear to me why that's an appropriate exercise of the function of attorneys general.
One other follow-up to this discussion. We've seen a lot more action in the courts, whether it's in your all's world on the plaintiff sides with private litigants or even with the federal government. We see a lot of action and a lot of policy happening in the courts, whether it's this pushback against the president by states in the other party, whether it's this litigation over opioids or big tech. There are a lot of issues that are just being decided in the courts rather than the political branches. So my question is, how much has Congress abdicated their role here, and how does that play into what you all see? And if there's a value judgment in my question, there's very much intended to be. So. What are you all seeing? Do you think you're in some more fights that you may not have been in had Congress, jumped into some of these policy areas and had they, updated some of these laws in the last 20, 30, 40 years?
I'll give a couple examples, real-time examples. We represent probably 10,000 ladies that use Johnson & Johnson baby powder, talcum powder. We've proven that it causes ovarian cancer. Litigation's gone on for 8 or 9 years so far, and Johnson & Johnson, one of the most profitable corporations in the world, about 3 months ago created a brand new subsidiary and bankrupted. Filed it in Texas. It's called the Texas two-step. I could not imagine this as possible. And so far, they're still in bankruptcy. And that's a situation where the Congress should step in. Just recently, 3M filed bankruptcy for one of its subsidiaries in the military earplug litigation. Unthinkable. And I think Congress is going to have to get involved. I think that's a great example of with lack of action by Congress in the bankruptcy code has allowed this to go on now for almost a year, and I think they're going to have to step in. So, yes.
I dissent. And taking cheap shots at Congress is a special privilege and pleasure of mine. But I don't think that those two examples yet illustrate that Congress is asleep at the switch. We want to have sober-minded, deliberate debate by lawmakers, and those are too recent, I think, to say that they should have overhauled the bankruptcy code. They should study it, they should look at the issues, they should eventually see it our way, because we're right. But
I don't care how long it takes.
Yeah, I am not yet ready to accuse Congress in that respect of not providing the policy answers that are appropriate for those sorts of litigation. And if I were going to take a cheap shot at Congress, it would be for violating Article 1, Section 8 all the time and passing a whole bunch of statutes that probably are outside the commerce power. I don't think that it's necessarily problematic that you're seeing a lot of this happening in the courts, because the issue to my mind is that Congress or the state legislatures have already acted, and if I were going to point the finger at someone, I would say it's the president who has not done a good job enforcing the laws, taking care that the laws are faithfully executed. And I think that that's a criticism that could be lodged at presidents of both parties. And I'm not going to take cheap shots at your former boss, but I think that there were violations of law that were happening, and the executive wasn't doing anything about it, or was perpetuating the problem with executive orders that were flatly inconsistent with the law. So to the extent that that's being litigated in courts, that's what Article 3 is for.
I would suggest that maybe some of that's going on recently, too.
Yeah.
Okay. At least we can agree on that. One quick follow-up on that is, I'm also seeing a new dynamic, and maybe that's just me, but where the federal government, and again, this is the current administration, the previous administration, we didn't really have this dynamic, where we were teaming up with other institutions and businesses to enshrine things that we liked in the law. That dynamic just didn't happen. But I see it a lot over the last year or so, where corporate America and academia and expert institutions are working with the federal government to enshrine certain priorities into federal regulations, even when it's against their seeming interests, or otherwise, using the power of government allied with private forces to coerce certain policy outcomes. A couple of examples that I'm thinking of: automakers supporting drastic emissions reductions. The U.S. Department of Agriculture recently moved to require certification of adherence to gender ideology to get funding for food stamps or school lunches. Or maybe even the massive pile-on between DOJ, the White House, and private actors on Georgia's election laws. I think we're probably about to see this a lot in abortion laws as well. How does that impact states and your work with them? And do you think states, again, might need to find new creative ways to push back?
Seems like your area.
Yeah, great. Yes, I think that is a major problem that you've identified. I don't know if states need to find creative ways, to use that word again, to push back against it, but they need to push back against it. What you're highlighting is, once again, my own anecdotal observation that the Milton Friedman principle is dead, and corporations are now fully woke and using shareholder money to push social agendas in a unified and coordinated way that I think is harmful to the American experiment. And so to the extent that elected officials in red states think that they have the political capital and a mandate to push back against it, and they have righteousness and law on their side, they should do so. I don't think it necessarily requires creativity, it requires courage. You have to be willing to take on a big corporate entity that might employ a lot of people in your state and maybe previously would hold chamber fundraisers for our team, but they're not on our team anymore. They're on the other team, and we should recognize that.
Are there other actors that should get into that fight? Is there anyone else left?
I mean, privates can certainly do it, but they have profit motives that necessarily are going to predominate over the social policy motives that I think state elected officials are better equipped to tackle.
So I guess the question that raises for me, and this is honestly just a question, it's my own instinct hearing that narrative that, well, if the government is pushing a particular policy and the individuals who are affected by the policy are okay with it, then what business is it of the states to step forward and object? In other words, what are the states claiming, what are the AGs claiming is as the basis for their standing to come into a matter like that and litigate it when individuals have not seen fit to do so?
Well, I think the answer is they're fighting for the little guy and the little gal who are going to be impacted by those policies, who don't have the clout of a Fortune 100 company just acquiescing to environmental regulations that are going to be bad for their shareholders. But ultimately, it's the purchaser of automobiles who's going to absorb those costs. And they don't have the wherewithal to hire fancy lawyers with white shoes on to go fight these policies, even when they're not consistent with administrative law or statutes or the Constitution.
So, I mean, is it a matter of, is it just a matter of economics? Like, you can represent the little guy in a case where you're seeking damages because you can work out a contingent fee arrangement, but if the little guy wants to challenge a regulation under the APA and get it vacated, at the end of the day, that doesn't create a pot of money for payment of the attorney's fees.
Yes, in that example.
One more, we're going to turn this over to audience questions, so here in a minute, I'll leave one more question on the table for everyone while I think there's some microphones in the audience if you all want to start queuing up. We've talked about how states disagree with each other a whole lot, especially the red-blue divide, especially when it comes to federal government powers and policy agenda items. And John, I will say that one of these issues is created by the states themselves because they do such a phenomenal job briefing both sides of the issue. They're really phenomenal litigators on both sides of the aisle who do, I can't speak from the guys and gals in black robes, but I do think that they do add a lot of expertise and value through their briefing. But even though a lot of splits go on partisan lines, Alabama and Massachusetts tend not to be on the same side of the case. The dynamics are quite different, as Gibson, you mentioned, when it was bringing cases against private parties. A lot of times these are bipartisan, multi-state actions. That said, here in Alabama, we do have a little bit of a interesting habit of not joining on the massive tort cases or maybe approaching them somewhat differently. John, I'm going to pose this to you first. Why do you think that is, and should we read anything in particular into Alabama's special nature on this course?
I'd like to think that the reason is because we've had a history of really good attorneys general in this state.
And solicitors general.
Correct. Again, it may just be anecdotal examples, and I feel like maybe I should just go down and tag team Judge Pryor and ask him about his experience in the tobacco litigation, but I believe, and I don't want to misrepresent the facts here, that Alabama stayed out of tobacco litigation at a time when most other states, if not all the other states, were getting involved. Most recently, General Marshall made headlines by not getting involved in an antitrust case involving Google, whereas Judge Pryor, then General Pryor, I think, eventually went on the record about his precise reasons for doing so. General Marshall has been pretty quiet thus far on the grounds that he's the matter's still under investigation and he doesn't comment at this point in time. And so the answer may be that there's no consistent reason why, in those two examples and maybe others, the state of Alabama has stayed out of certain litigation. Judge Pryor's answer may have been, well, with respect to that particular litigation, I don't think that the claim is meritorious. I don't think it's proper for the state to be involved in that litigation, and we're not going to do it. It's entirely plausible that a different reason for staying out of, say, a big collective piece of litigation that all the other states are plaintiffs in is that you're sort of on the other side of the spectrum. You actually think the claim is really, really good, and you would prefer, as the AG, to be in complete control of your particular piece of litigation rather than entrusting the ultimate result to, say, the AG in the state of Washington or some other state where you're just not as heavily involved. And I would think, from the perspective of a private party that was sued by the state, I would much prefer that outcome. I would be much more concerned about being on the other side of the V in a case where you've got 50 states involved and some AG's office that may not, that may not understand the dynamics on the ground where I actually do business. As Ashley suggested, I do think at the end of the day, to the extent that someone like me might have concerns about AGs bringing cases as plaintiffs, they ought to be assuaged to a certain extent by the notion that, by the assurance that because the AG represents the state and is under an oath to execute the law faithfully, that they're going to only bring cases when they've thought about it really carefully, and they're going to make responsible allegations and steer way far away from the Rule 11 side of the line. But regardless, the answer to your original question is that, again, maybe the folks on the next panel will help elucidate that, but there's probably no consistent reason there.
Ashley and Gibson, obviously you've represented a number of plaintiff states as outside counsel. Obviously, give you a chance to weigh in.
Yeah, it depends on the state, it depends on the issue, and it depends on the Attorney General. I know that Attorney General Marshall's passed on certain litigation, but also Alabama was one of 36 states that recently had a big settlement with the Jewel litigation, the kids using vape. So I think it depends. John, I wanted to ask you, I know you're not a big fan of the state being the plaintiff. Do you have a problem where state AGs hire outside counsel?
Since I'm one of those counsel, the answer is no.
I meant on the plaintiff side.
Do you have to recuse from answering that question?
That's not one of my hobby horses. No, the question is how the litigation gets most effectively prosecuted. It gives me great heart, Gibson, to hear that, for example, in the Marshall administration, it sounds like you guys are working hand in hand with the Attorney General. Just as I mentioned earlier, I don't feel like my job as outside counsel for the state is all that different from my job as inside counsel. I don't do anything unless the relevant officials tell me it's okay to do so. If the officer whom we've trusted to wield this pretty significant power is in fact exercising that supervision and control, I feel pretty good about whatever sort of outside counsel fee arrangement has been developed.
Perfect. Thank you.
Yeah, I'll just say I'm encouraging states to be more active as plaintiffs, but in any individual case, I think that the Attorney General or whoever is charged with responsibility for making a go, no-go decision, if they determine that the merits aren't there, even if they could get a pot of money, even if I advise them, hey, the merits aren't there because of our principles, but based on the principles of the judiciary you'd be litigating in, you could get a pot of money. If they determine it's not a good case, I think it's their responsibility as officers who are charged with an oath to their constituents to not bring that case. And I think it's great when they choose not to do so, even if it's bad for my bottom line.
At this point, if anyone has a question, please come to the microphone. If not, I'm going to have to ask some boring questions about, standing or, I don't know, ethics. We're all getting CLE credit, so I can, do I have to do anything special for that? Well, let me ask one question. Maybe this is for you, Gibson, while we're letting folks mosey up. When you've got people on this, I see some moseying. I'm going to table my question in deference to Judge Pryor, Chief Judge Pryor.
All right, so I've got to ask, I think the question about novel legal theories was totally dodged. And that really started with the tobacco litigation. Right. The idea that an industry peddling some legal product could be a public nuisance was invented during the tobacco litigation. To my knowledge, not a single state Supreme Court has ever endorsed that theory. In fact, some, when they encountered it in the tobacco litigation, repudiated it. I remember the Supreme Court of Indiana ruling that, and the Attorney General of Indiana at the time holding a press conference and throwing their ruling in a trash can in front of the cameras. You know, great moment for the rule of law. So I'm wondering whether I should feel really comfortable with the idea that the real check on this has been principled attorneys general, when what I really see is further development of this kind of litigation, where there appears to me at least to be an extortionate potential. I'm not as familiar with the details of the litigation that has come later, but I do know there have been further lawsuits. I think opioid might be an example, where public nuisance theories are being asserted against an industry peddling a legal product, even if there are problems with how they do it. It's never been endorsed by any state Supreme Court that I know, but when you have 50 states or 30 states or whatever it is ganging up together, financed with lawyers who, maybe as a percentage basis, modest contingency fee arrangements, but with an upside of $50 million, I wonder how much of a check that is and whether that is something people in this room ought to be concerned about.
Ashley?
This isn't an oral argument, so I don't just have to agree with you, and so I won't. I object to the notion that the question was completely dodged. I think I said very clearly, I don't like novel theories. I believe in history and tradition and the original public meaning of the Constitution, and I'm generally against novelties just so that you can stick it to a corporation and raid their coffers. So I think I did answer the question. And in opioids, to give you a concrete example that you brought up, Arizona's primary theory is based on a violation of a consent decree. Right. So there was a consent decree entered through a court order, and the accusation is that Purdue repeatedly and the Sacklers repeatedly violated it, and Arizona, through a statute, has statutory penalties associated with that. Now, if you multiply the statutory penalties by the number of alleged violations, it would be trillions of dollars. And so could that be used in an extortionate way to put too much pressure on the company based on that, I think, much more clear-cut, not novel theory of liability? Yeah, it could, and you do have to trust that the elected leaders are going to take their foot off the gas at the appropriate time and say, we've mulcted you enough, this penalty is sufficient enough to compensate for the wrongdoing. But it is really significant wrongdoing. 70,000+ people a year are perishing because of the opioid epidemic and the violation of the consent decree that's alleged. So I do think that hefty penalties sometimes are apropos, but I'm with you. Novel legal theories just to get a pot of money, that's what I do for my private clients who don't have as much clout, but it's dangerous when wielded by public officials. And that's a legitimate question that we have to take into account, even as I encourage more plaintiff side work by state officials. But I answered the question.
Maybe somebody else did.
Well, I would echo what Ashley's saying. It's just one of the many theories filed in the lawsuit. And to your point, not all these cases the plaintiff have prevailed. I mean, just recently, a county in West Virginia, really ground zero, went to trial and lost on the theory of nuisance. So I would say at this point, it's evolving.
I'm curious, and I have to be careful about what position I take on these particular issues in light of the conflicts I disclosed at the outset. But in cases that don't involve the Arizona penalty statute, if we just take for granted that the defendants did bad things and that individuals were harmed and entitled to some sort of redress, what is the state's role there? Outside of any statute that provides for penalties, what is the state's theory under which it's entitled to damages? And is that a novel one or not?
Well, there was a consent decree with the manufacturers and the states where the manufacturers came in and said, we mathematically realize that if there are X number of people in this area of the state, they should take no more than X number of opioid pills. And then the facts bear out that it was 100 times what they agreed to sell.
But I guess my question is, how does that harm the state? What's the state's
Right.
injury?
Well,
in
because
fact?
emergency rooms, Medicaid, I mean, the state is left picking up the pieces. You have to hire more first responders. I mean, a lot of different damages.
Said differently, I should be careful, but I won't be. It's an aggressive damages theory, a novel damages theory. We spent more money on police and ambulatory and other resources because when you have drug-addled people in the streets causing crime, that has an impact with lots of repercussions. And if you were reading Paul's graph that day, you probably would say there might be a proximate cause problem here. And so it does take some novelty for some of those theories, not statutory penalty theories, to be successful. And we've already talked about whether we do or don't like novelty. But I would be willing to concede that the damages theories for some of these nuisance claims are not what you read about in law school.
Judge Brasher?
Yeah, so I was wondering if y'all would just address this criticism of contingency fees, which I don't know if I agree with, but you hear a lot, and I'm curious to see what you think about it. The criticism is this, that when we fund the government, we expect a certain amount of enforcement of the laws, right? So the laws are being passed all the time. We don't actually expect all of them to be enforced to the nth degree. And one way that we restrict the government's enforcement ability is we don't fund it that much. And so John Nyman has to work for, a pittance to represent the state. The contingency fee arrangement gets you out of that because it allows the state to enforce laws in a way where they don't actually have to appropriate money to get that enforcement. And so through the contingency fee system, do we get an over-enforcement of laws that we would otherwise not get, and maybe that we would sort of expect not to be enforced in that particular way?
No.
And why would that be?
Because in addition to the laws that allocate the budget to the law enforcers, there is a law in every state that talks about contingency fees and what you're allowed to charge. And so ostensibly the lawmakers took into account, we're going to have this pot of guaranteed money that goes to the official law enforcement agency, but we're also going to empower them to take on outside counsel with contingency fee arrangements because we think that is the societally optimal level of enforcement, and we need outside resources sometimes in order to properly get that level. So if you're going to rely on the fact that the legislature is giving a certain pot of money every year, you also have to rely on the fact that the legislature has already contemplated that people like me should be hired in certain circumstances and have given discretion. And it varies by state, by the way. So for example, in Texas, the legislature had to separately approve some of the cost and fee reimbursements that we're hopefully going to eventually get with respect to the Google antitrust case. And so the legislature specifically debated and said yes to the outside counsel arrangement that was ultimately inked between my firm and the state of Texas.
Sometimes it's good business, sometimes it's not. We represent a state where we've already reached the cap. We probably have $10 million out of pocket in expenses, and we're not through with the litigation. So in theory, we may be representing the state for many years to come without getting paid. And part of the payment in the opioid litigation may be paid out over 17 years. I probably won't be at the firm in 17 years. So, we asked to do it. We enjoy representing states, but sometimes financially, it's not a windfall.
Gibson, if you need an introduction to any litigation funders, I'm your guy.
Gentlemen, we really appreciate you all joining us this morning. Thank you all for having this panel. Thanks, Justice Mitchell, for introducing all of us to each other so we could be with you today. And thank you for joining us.
Thank you, Andy.
Thank you. Really enjoyed it.